Hi, I'm Greg Dell here with attorney Stephen Jessup. And Steve, we're doing a couple videos talking about the new ERISA regulations that were drafted by the Department of Labor after a lot of feedback from lawyers, insurance companies, defense attorneys, any other advocates or community or groups that were interested in what the regulations would be. They came out in 2016 December, and they gave the companies basically until April 1st of 2018 to implement these procedures. So they're really new. We're just starting to see them roll out, and there's probably 7 or 8 changes that they end up coming up with. But there's one that probably is the most important for claimants, and it's one that our law firm actually has a history with, where I'm really glad to see this law change, because we were on the losing side of this like 10 years ago in the 11th Circuit Court of Appeals, where we had a claim where we, on appeal, we submitted an appeal, and on appeal they hired another doctor, and that doctor issued a new opinion and rendered some kind of opinion that we never had the opportunity to respond to. And we're like, wait a second. You go on appeal, you hire a new doctor who we have no idea about, who you never used previously, and then you don't give us the opportunity to comment on that. And we lost that case. It's one of the few that we did actually lose in a district court. We filed an appeal, the 11th Circuit Court of Appeals, and the court said, no, we're sorry, ERISA doesn't provide for you the opportunity to comment on what they did during the appeal process. So it's not a tit for tat, back and forth, you get a chance, we get a chance. No, the law was at that time the insurance company is going to get the last say. So we debated for years. We spoke to Congress people, we spoke to the Department of Labor, we did everything, complaining about it, and just this became horrible law. It was terrible. So fast forward now to this new regulation, and they come out with a new regulation that basically says that if the plan will rely upon new evidence or rationale to support its denial on appeal, the plan must provide such information to the claimant as soon as possible and sufficiently in advance of the date on which the notice of the adverse benefit determination on review is due. So what are your thoughts on this, and are you starting to see it, and what kind of impact do you think this is going to have on long-term disability claims?
I'm a bit cynical. We've been seeing it. A lot of companies were doing this prior to 2016, but more and more now are, where during the course of an appeal, they will send you the reports that they had from the reviews of their doctors. And they'll say, you can send them to your client's doctors. They have X amount of time to respond. If we don't hear back, we're just going to proceed with our review. As you know, it can sometimes be difficult to get a doctor to respond to something, getting the paperwork and these timelines and deadlines. So in some cases, yes, the doctors respond, it's very helpful, but just on the double-edged side of it, now the insurance company's saying, to show, especially in an arbitrary and capricious review, look how reasonable we were. We gave their doctors an opportunity to respond, and they didn't. We did as much as we could to try to see if we could approve this. So it's really a double-edged sword, but the takeaway is at least you're getting the opportunity and the chance. How many times did we see it where they'd say, well, we reached out to the doctors, we didn't hear back, and we never knew about it. They didn't at that time have to let us know about it.
Well, that was the norm.
That was the norm, so you were getting blindsided by it. So this at least allows another avenue to respond to anything new that they may bring up before there's a denial. In the case you discussed previously, it was a new argument as to the basis of denial. So now you have the opportunity, but now the insurance companies can even use that to their advantage, saying doctors never responded to us. And then we took the doctor's opinion and we sent it back for a further review, and our doctors disagree. We're going, upholding whatever. So it's almost like allowing them to build extra layers of showing how reasonable they were, especially if the ultimate legal standard will be arbitrary and capricious.
I think it's going to raise the caliber of appeal that a claimant would be expected to submit, because now their doctor did an opinion, they send it back to you, and now a claimant who doesn't have legal representation is going to try to respond to that and try to get their doctor to write an appropriate response, whereas someone like, when we do these claims, we've done thousands of them, we know how to take that in, then get in touch with the doctor to try to dissect what they did or possibly get another professional opinion or some kind of test or something in a quick time frame to try to rebut what they said, or so often we'll get medical literature to totally contradict whatever they are, and just pad that record with more and more information so that if the claim does get denied, we still always have to assume they're going to have an arbitrary and capricious standard, which means we want to show they acted unreasonably by not fully reviewing the claim and just hiring some what's often a hired gun doctor. The other thing we can do when we know who the doctor is we can look to get into the record impeachment material on that particular doctor. So can you explain a little bit what that means, like if we wanted to get some impeachment material?
It's basically a way to try to discredit that doctor if there's something out there about that doctor, if there's case law that references the doctor and how often the insurance company's using them, and that information does exist, or being able to look to see if there's any complaints against the doctor in any database. One insurance company recently, I believe it was Cigna, they sent letters out to a lot of insureds advising them they were using a doctor who was not a doctor and lying and using someone else's medical license to give opinions, which the insurance company was relying on. So it's a way to try to show that the doctor they're using is that hired gun, or to discredit their opinion, in any way that you can.
Yeah, so I don't know if all of these companies are going to say, okay, we did a medical review, or they did an IME exam, and now the protocol for them is, okay, now we're going to send it back to the claimant to say, here's what we got, what do you think? The real thing that's going to come, and this is really new, is, okay, when they do send it back, how often are we really going to change their mind? And then the other thing you got to balance is, if they do send it back, you are right now, what's going to happen when they say, well, we sent it back to them and they didn't say anything, but what if the report they sent you is so awful, misses so many things, that now you're running that balance against did they act reasonably or unreasonably, and now giving them a chance to fix their error as opposed to zinging them when you file the lawsuit. And that's a case-by-case analysis that we debate amongst all of our lawyers on every case we have once we get one of those reports back, and say, look, this doctor did such a botch job, we're going to win this case. But if we point it out, are we really getting that much more evidence to win the case, or are we just making the case for the insurance company? So that's the ongoing debate that how many times a day do we have that conversation on every file? So that's something that a claimant who doesn't do this every day and isn't in the pits doesn't necessarily understand. The other challenge that a lot of claimants have is the doctors don't want to be bothered by the insurance company. And now they got a letter or a report from a doctor is basically saying, hey, what your doctor said is wrong. Some doctors get pissed off and say, yeah, I'm going to help you and do something. And some doctors are like, no, I don't want to do anything. So what does a claimant do in that situation when their doctor's like, I'm sorry, I just don't have the time to do it?
It's a horrible catch-22. It's really a lot of ways too when doctors don't want to get involved during the claims process, to begin with. And there's no way to force a doctor. They're under no obligation, ethical or anything like that, to a duty to complete paperwork for an insurance company. So it becomes a real difficult problem. That's a huge uphill battle.
Right, especially if you're not represented. Because when you're represented, we can call the office and say, doctor, we'd like your time, and the doctor will say, okay, I get $500-600 an hour, and if you want 30 minutes, it's going to be $300, and you can take my statement, or we can talk together about a report, and that's what we do all the time.
And also, a lot of times too, since these doctors do have disability policies, but they're individual, it's kind of a different realm. Usually when I reach out to doctors' offices, I let the doctor know that, if it's governed by ERISA, they're not going to be deposed, they're not going to be called to testify, that this will not impact their practice. At most, they may get a call from the insurance company's doctor to discuss, but they don't have to worry about being on the opposite end of a questioning from a defense attorney or anything like that. So sometimes that kind of eases their minds too, and they know, all right, it's my written, information a judge is going to look at, and that can help kind of massage it. But, you sometimes still are faced with they just don't want to get involved.
Right. So overall, my take on this change is I think it's a step in the right direction. I'm happy about it. I don't know if it's going to make a big change, but for the past 10 years, I've been really disappointed about that old case. And it's always been a weakness that a claimant had to say, we'd always say, we submitted this great appeal for you. Then they came up with this other doctrine, this other review, and now we go to argue the case in court, and we have no ammunition to go against that. So we're definitely bringing it more towards a level playing field by having this opportunity to do this. So my personal opinion is that it's a really good thing for claimants to have this. How the insurance companies actually, whether they all implement it or not, I think they will eventually. It's so obvious to say you have to give them the opportunity. Some will do it better than others. So we'll see. The only thing that a claimant's going to struggle with this is that all of this is supposed to go on where they review your appeal, you know, get another doctor maybe to look at it. If they do, there's no obligation for them to do that. Get it back to us and then have us comment, and it's supposed to all happen within 45 days.
Well, the other flip side of that as well, though, is that when they send the reports out, a lot of times they'll say we're going to toll that time frame until the deadline to return it, so it's dragging things out as well. So it gets kind of tricky with the dates, how many days have elapsed for purposes of having that timely review conducted.
And you know what? It's going to be interesting to see how these regulations affect that 45-day tolling that you just mentioned, because I don't know that the courts are not a big fan of them saying, because they, you know, the insurance companies play that game and say, oh, we asked you for this, we're tolling the days. So I don't know how that's going to fly. Again, we're going to find out. So anyone that has a claim with any of the long-term disability insurance carriers, feel free to call Steven or any of the disability attorneys here. We represent claimants nationwide, and we always offer you a free immediate phone consultation. We look forward to the opportunity to speak with you.